Good morning, friends. Sat Sri Akal, Adab and Namaskar. Now, this is my 206th video, and this is a series which I just mentioned in my last video. We'll be covering some cases of Ambala Cantonment. These cases were very well fought. Either we can put them like this, or they could be taken up as a discriminatory cases, that these bungalows, even after being issued resumption notices, were not withdrawn, were neither appeals were filed. The department did nothing to pursue these resumption notices further. Maybe because there was a closure report, maybe because these bungalows were fought very well. So today we are going to talk of a bungalow name numbered 29A, or either this bungalow number, as per various documents from 1905, speak of 329. Now this bungalow, when was originally given, now to the original lessee under the 1899 Cantonment Code, presently this bungalow was in possession of the family of my late president Mr. Kumar and his brothers. So there were three in number. There was another one, but he had moved out. I'm within the family, maybe there is a partition. So the original three owners, from their mother Munni Devi, the inheritance or the GLR amendment has not taken place till date. I have the GLR of this bungalow. Now Lala Mahesh, who was the original lessee, was originally granted under the 256 section of the Cantonment Code. Now this section very clearly says it is a perpetual lease and under 14th May 1905. And the area which was given was 8.79 acres. Now friends, this is very important to see that this bungalow originally holded an area of this. In coming period we'll, and this, when perpetual lease was given, it was told to Lala Mahesh that he will construct the Cantonment Board office, he will construct the Cantonment Magistrate's residence along with the Cantonment Magistrate Court in this bungalow 29A or 329, and with a rent of about 200 plus to be given to him along with the loan for constructing this bungalow. So this lessee actually sought in 1925 that he may be permitted to sell one part of his bungalow for rupees 60,000 rupees. Now there was a board resolution done under number 35-1 dated 21st October 1927 that for 20,000 rupees a proposal had been mooted by that the Cantonment Executive Officer or the Cantonment Magistrate Office would be purchased. So the GOC in Northern Command, who used to sit in Rawalpindi then, approved this, and finally this approval reached the owner. Now it is very interesting, after all these approvals, board proceeding, there was a legal opinion given by Advocate Khan Shaheen Nazir Muhammad. This was on 13th March 1928. He says this bungalow has been mortgaged. Now understand, 1905, a bungalow under 256, lease is mortgaged to Lala Banarsi Das mill owner, and a court case is pending for recovery of that mortgaged or amount. So finally everything settled and Mr. Lala Banarsi Das is bought in as a party, and a conveyance deed is made which is registered on number 87, book number 82, page 336 on 11th April 1927, and the Cantonment Board pays 20,000 rupees and the bungalow is bifurcated from 29A to 29B. Now that means there is a division between the lease or the grant So bungalow number 29A remains with Lala Mahesh, and 29B, which is even on date of 2024, is the Cantonment Board Office Ambala. So friends, we can dig into our records. Later this bungalow changed hands, and Srimati Munni Devi, who applied for repair permissions under a board resolution 10 of 17th September 1959 to repair now the bungalow is 329. It is no more 29A or B. Racecourse Ambala Cantt. So the bungalow now has changed its number. So the MEO then writes to the DG military who sits in Rawalpindi and states that this original lease was on Form B, which is considered to be outside the civil area, and an annual rent of 17 rupees 90 anna was being paid to this owner as lease money. So what are we thinking in this? Is this bungalow being derequisitioned? Here the letter speaks that when this GLR of Ambala was being prepared at Rawalpindi, the mistake done was that the original bungalow 29A, some part of the bungalow was taken and converted into Class C land, and that area was 1.90. So the GLR speaks of what? The area left after what was the original area? Approximately 8.79 acres. So 1 point something of the acre has been already taken over. So let us make sure that the GLR speaks the right area and the right thing. So 1928 and 29, the first GLR for Ambala Cantonment was being prepared, and there was a mistake in this one cantonment case. Finally, there is the lessee is allowed in 1941. 59 he applies, and 41 I have a letter to enhance his built up area. Their letter comes out, and this is that he can add a bungalow into it, and for added construction in bungalow number 29A, his lease money will increase from 13 rupees 12 anna 3 paisa to 23 rupees 12 anna 22 paisa 12 paisa 3 anna. So if you increase your construction, your lease money increases. This means there is a precedent here. Now the station headquarter, now after independence, there is a correspondence which dug into my research record that since this bungalow was on a hire with the army, it was to be derequisitioned in 1948 and should be released and given over to the original old grantee. And this bungalow during that period only had constructed a new house for cantonment magistrate. So the present now we talk of. Why did I talk of this history? Because this record came in my hand in a court judicial case. And then I asked the department at that time in 2008, which they were very reluctant, but then I did manage to, through my sources, see the records maintained in the Cantonment Board Office Ambala. So this bungalow number now holds 5.43 acres of land. Originally 8.93 has come down to 5.93. So the balance land has been taken over. Bungalow number 29A has been reduced to this area. Now the number has been even given a survey number. 1905 it does not hold a survey number, but now it holds a survey number 152. And you will be surprised, after this resumption notice given to the bungalow owner, even the GLR has been amended, and from B3 it is written A1 there. The copy is with me. What do you do? So, if you number these orders and you number what the department, now I even have a letter of 1940 where this bungalow owner was issued a notice under section 140 of 1924 Act that your bungalow is in a dilapidated situation and you need to repair your bungalow and make it good under sanitary conditions. So that means bungalows were, if they were dilapidated, they were asked to build. So today if we repair our bungalows, why does the department issue us a notice under 185? That's the question. So resumption finally takes place on 2nd March 1971. The owner has even asked for repair permission after this resumption notice on 16th December 1972. Now just imagine, 71 the bungalow is resumed, bungalow is already on hire with the army, and in 72 the HOR is asking, this is my late president and his 3 brothers asking for repair permission, Munni Devi's children. So a letter in 1972 rotates from CO to DO and he says that since the bungalow has been resumed, so there is no point or choice to accept this letter for repair. And the bungalow is already in possession of the army. So the DO is supposed to inform whether the resumption has been completed and the possession has been taken over. So 71, 72, all these correspondence is happening. Now the bungalow resumption notice 71053 of 10228, 30th January 1971 mentions his bungalow number 329 Staff Road. So the bungalow owner now goes into a writ number 871 of 1971 and a civil writ 1345 of 1971 against this resumption notice. Now it is very important, this writ is moreover dismissed or withdrawn after a statement given by the Standing Counsel of Union of India, Mr. Diwan Chetan Das, Additional Advocate General appearing on behalf of the Union of India, gave a statement that the property would be resumed in due proof of law and the after possession would be taken under the provisions preludes under the Eviction of Unauthorized Occupants Act. In view of that statement, the petition was not pressed and was therefore dismissed by the Honorable Court. The judgment is in my hand. Now this case comes back. So the owner does not file a suit because the High Court has said and the admission has come from the MO that they will file a PP Act notice. Was that done? Till date 2024, no PP Act notice for resumption. Instead, I'll share it, this bungalow was de-requisitioned also after this pendency. This bungalow owner even filed a suit, and I'll come. So nothing happened. This bungalow owner filed a suit for recovery of rent and damages of the building. I yet remembered, Mr. Rajkumar used to visit my father during this period and they had a munshi. I don't remember his name, but I always used to think that he is their father. As a child, I used to see them in 70s and coming to my dad's house, 75. So this guidance came from my father that you file a recovery suit since you've already won from the High Court writ and the department needs to file a PP Act, which they are not doing. So you file this. So a case is filed, civil appeal number 2115 of 1977. The date of decision is 21st February 1977. Very small decision. The decision was simple. And this case was filed by Mahesh Chandra, Ramesh Chandra, Suresh Chandra and Raj Kumar. So that means Munni Devi's 4 sons were the original inheritors of this bungalow. So this bungalow is directed by the first class magistrate, passed a degree for a recovery of 4,234 in favor of the plaintiff. The brief facts of the case is this: Bungalow was the Union of India through Ministry of Defence is the owner of Bungalow number 29A, land attached to, situated on racecourse, Ambala Cantt, is on perpetual lease for an indefinite period with the plaintiff. The lease money is so and so. The predecessors and plaintiff in 1905 were the owners of the superstructure, and they were being paid of this portion of 29A 104 rupees rent, and the Cantonment Magistrate office rent was about 102 rupees or something. So according to these conditions, the defendant issued a notice that is of 30th January 1960. The plaintiff is sending to the property. The compensation received is 6,253 rupees. So where is that eviction proceedings? Where is that possession proceedings? But the entire property has a peculiarity. For that reason, I made this video for residents. They, if dig into their land records and files maintained by the CO's and DO's office, they will come across amazing things. Bungalow numbers have changed in 1905 to 1924 prior to the Act, because CLA rules in 1924 Act was coming in. So the army thought, or the British thought, let's change bungalow numbers, give them new numbers, because prior to that they were dividing grants, they were bifurcating grants, they were converting grants into leases. So one portion of the lease, I have a lot of registries of Ambala, half of the bungalow is on lease and the half of the bungalow is on old grant. So these things were happening, and we can all take out these documents and we can fight head on. So now, is this case a master case? That since the Attorney General in High Court speaks in 1978, why isn't the MEO filing any PP Act on this case? Why the resumption proceedings are not taken to the next level after 1978? So there are so many questions. So is it a breach of the Constitution, or is it a breach of the law of the land that a resumption notice cannot be withdrawn by the DO, MEO or DG land? Has to be done only by the ministry or by the courts? So again I say, read that chapter 20 through in volume 2 of the Cantonment Act. Who are the people who have to be punished for this connivance of not filing an appeal? So this becomes an exemplary case. But we bungalow owners at times, we just want to sleep over to all these facts. Why? Because we don't want to be a party to all them. We don't want to have a grudge with our neighbor or ex. It's not about grudge. It is only about what the department does. And believe me, I'll share it with you. The department knows that we are not one. We are a divided lot. So please friends, wake up. And this is an exemplary case. Perpetual lease, 2012, there is a Supreme Court judgment. A judgment which clearly says if a lease, even in perpetuity, is on terms and condition, does not mean. And this Form B judgment, lease section, what do you call it? You may call it a subpara 18 has that the bungalow can be resumed after giving 1 month notice. Why isn't the department moving forward? We need to check into all this. It's because we were old grants. And this is a case in 1905. You convert an old grant into a lease, that also in perpetual. So get up friends. Good day.